what really matters is, Alan, we're going to hand over to you in terms of this is all about actions to take forward, isn't it? We have heard so much today, including around consumer-focused regulation, including around training, including around the issue of more regulation, more voluntary regulation, more targeted regulation, including regulatory visibility, and including regulating for innovation. So lots to deal with, and that's just some of the points. But let me hand over to Alan for this final session. And you'll never believe it, but we are a minute ahead of time. Not for long, I know.
Thanks very much, Elizabeth. That gives me all the time in the world, so I can say whatever I like now. Thank you all very much for contributions so far. And we've had an extraordinary, as the word rich keeps coming up, but some very good presentations, and particularly taken actually with Lee Castleton's reflections this morning and understanding what it's like to be out there and the receiving end of this kind of thing. Well, we can talk in abstract and talk in terms of general themes, and when it's real lives, it's very different. And that's a message that's pretty clearly here, which I know is known to many people in the room, but which needs to be reinforced regularly, because that's what we're about. I'm just going to pick up on a couple of themes. I'd love to say I'm here now, I'm going to draw it all together and tell you what all the solutions are. Actually, that's exactly what I'm not going to do for obvious reasons, but I'll invite my colleagues to reflect on some of these things, and I'll give them all the floor in a moment. We've heard some horrifying things as well from out there and what it's like in the kind of charity sector and so on, people trying to help people who are almost beyond that point, and some pretty frightening stories and depressing and moving stories from out there as well. It's not all about that, of course, but again, remember real life, because regulation can sometimes be one or two steps removed from that for perfectly good reasons. One or two quick bullet points then on things I've particularly been struck by. The interesting change, before and after OIS's talk about AI and perceptions about how comfortable we are with it, moved quite a long way to the right, if I got that right, but I believe it did. And that's very interesting. And again, it's about familiarity and about everything to do with change being about becoming familiar with it, understanding what it looks like and understanding what it can do. And actually, rather than the myths, rather than the headlines, never base things on the headlines that you see. The point about that Lee made so powerfully, that everyone is a regulator. I would say this doesn't in any way mean that everyone's a police informer, but what it means is that there is a collective responsibility among professions and the people they deal with to be looking out for each other and looking out for what is right and ethical and good. And if we can't always make the world a better place, at least behave ethically within that. And that means the psychological safety to speak up, whether it's on a governing board, whether it's in a partnership, whether it's in a large firm where you're under pressure to deliver things that maybe your professional ethics say you shouldn't be doing. Where is your backup for that? Where is your support? We've heard that the SRA have some draft guidance they'll be consulting on in due course, and maybe Anna will speak about that. But the pressure's on the in-house lawyer, inevitably, in a slightly different case from the person in everyday practice or self-employed and so on. So everyone's a regulator. We're all in this, and regulators themselves, the regulatory bodies, as it were, drawing that together and providing focus for it, providing the guidance and dealing with the things that go badly wrong from time to time, as they do everywhere. I've heard a determination to tackle things. I said at the outset this morning that much as I'm interested in people's plans and propositions and so on, what we want to see, particularly what we at the LSB want to be challenging regulators about, is, are you producing the results? Is your plan producing the results? What are the outcomes? What are the outputs of this? We'd like you to tell us all about the activity. We hear about loads of that, but what are the results? Is it doing what you thought it would do, what you said it would do? So guidance to professions, but constantly improving that, constantly seeing what works and what doesn't, listening to find out what works in real life. We also heard the point about visibility of regulatory work, and this isn't quite as simple as it sounds, because a lot of the time with monotonous regularity, regulators are doing what they're meant to do, and regulator does its job is not a headline. However much you try to make it, it's not news, it's not interesting, which is great, because if it's not news, then it probably means it's okay. But the point is, how do we make that more visible and ensure that people know? And sadly, it's often in the tragedies and the scandals in which that gets its exercise. About guidance being about high level and about emphasizing the principle. We heard a little bit this morning about elaborate codes of guidance. The more elaborate, the easier they are to drive around. The more words there are, the more words there are to argue about. The fewer words, there'll still be arguments about them, but there are fewer to worry about. So very basic principles being underlined all the time and then outworked in specific areas of guidance. And then with AI and the developments there, we're looking already, as you know, at the use of technology for access, and we'll be working more with the regulators about that over the coming months to make it easier for people to use legal services, indeed to do some of the work themselves, perhaps, and do that sort of unbundling that's been talked about over so many years, but also enabling access for places where it might not be possible simply to walk down the street and find a lawyer's practice of someone who can help you. So that's one area. But on into AI, and what specifically regulatory demands might there be there? And this goes across professions, and it's one where no one's got a solution yet, but ideas, themes are starting to form about accountability, about who's responsible when things don't go right, who you blame. You don't blame the machine. You have to have an accountable person for it, or an accountable process. What sort of choice? How do you select the right tool to help you, and which is not going to have unforeseen consequences? And how do you find tools which are based on fair assumptions and are not skewed in certain ways, which might disadvantage different groups as an unintended consequence? So just a few thoughts there ever so quickly. And now I'm going to turn to my splendid colleagues who are each going to say a few words. So Anna Bradley from SRA, David Heath from the Cost Lawyers Standards Board, Kathryn Stone from the Bar Standards Board, and Chris Smith from the Intellectual Property Regulation Board. And I'm going to ask you in that order, just to say a few words, and then we'll try some questions. Anna.
So I think one of the really good things about today has been the fact that we've had so many people with different perspectives in the room, people with different experience. And I think that speaks to the fact that increasingly the issues that we are addressing as regulators are not sectoral. They're not just about the law, they're about much broader issues and questions. And the truth is that, there's two tendencies in that environment. One is for lots of people to say the regulators need to solve all these problems because we're the only people you can see who might have some tools to be able to solve these problems. That's not right, actually, because that is putting far too much weight on what regulation can achieve. The other one is for regulators to say, that's not our problem. We can't do anything about it. We'll turn our backs and walk somewhere else because someone else needs to address this. It's not up to us. And it's thinking about those two things, which I think are really important as regulators, and something that we've been thinking about a lot at the SRA. But I go away with renewed energy from today, which is the importance of collaboration, because we won't solve access to justice as regulators. We have a very important part to play. We won't solve issues around ethics as regulators. We have a very important part to play, but working with others is the way that we're going to get there. I think, if I may, Alan, I just say one other thing, which is more about some of the more SRA specific issues, which is to pick up the point you mentioned, visibility. So we have a lot of work in train in relation to in-house. As has been mentioned, we're about to publish some new work, some new proposals next week. They are proposals, they are in draft. We're wanting that collaboration to talk about what people think about them, whether or not these hit the spot, and will help to address some of those issues. I should say probably in relation to in-house also, that actually here's another point of collaboration, because the role of auditors in companies and the extent of internal auditors and the extent to which they are protected by their specific mention in the corporate rules, gives them protection which General Counsel don't have because they're not mentioned in those the corporate code. And I think that's something that we need to be picking up with the FRC. The other thing is in relation to the post office, that I just want to dispel any idea that we're doing nothing. As one of the speakers said, effectively without any briefing and not on our behalf, but absolutely spot on, we are doing a huge amount. We are wading through huge amounts of documentation. We want to be ready to go as soon as we can. It is in the nature of inquiries, as it is in the nature of criminal action, that the regulators would normally wait for that process to be complete, but that doesn't mean we pause. And indeed, we're in constant conversation with the inquiry, including only last week when they've agreed to release to us a whole series of other bits of information which we've requested. So this is a very active dialogue. But it's not visible, and I kind of want to say it's all there on the website, but that means you have to go there and find it. And my question to the audience in a way is, well, what could we do that would help you to find it or make it more visible to you? Because there's a whole lot more going on underneath the bonnet, and where we can, we will tell you about it. But you obviously don't always know about it.
Thank you very much, Anna. I'll go straight to David.
Thank you. I think three main takeaways, or in sort of headline terms from today. The first touches on something Alan's already said, which is the value of collaboration and cooperation. I would say that, wouldn't I? Because I chair an exceedingly small regulator with an exceedingly small regulated community, and in fact, there's more people from the SRA here at this conference today than we have in our entire workforce. So you know, that gives you some idea of scale. But yes, there is a huge amount to be gained from exchanging ideas, exchanging information, exchanging things that people have done. And that applies not just within the legal regulator family, but also with other professions in a world where professions are increasingly porous, where you have multidisciplinary companies of various kinds. Let us explore what other people are doing, not just in other professions, other sectors, other jurisdictions. Because we have everything to gain. Second is on the very important point we were discussing this morning about rule of law and professional ethics. And you've already picked up on Lee's point about which was an exceedingly good point about it being the responsibility of each and every lawyer in the room to stand up and say, no, that won't do. And I think he's absolutely right. But there was also a question from just behind where I was sitting saying, and what has the power and the spending power, particularly of the client, got to do with the degree to which sometimes rules are bent? And I thought that was extremely important as well. And I think if we can increase both the rigor and the profile of our support as regulators for the rule of law, for professional ethics, it does two things. So first of all, it perhaps moves people away from ghettoizing ethics as something that compliance does down the corridor, and therefore we don't have to worry about, which I think is important. Secondly, I think it also provides a defense to the junior lawyer who has to stand up to a senior partner, to somebody who's an in-house lawyer having to speak to someone who's got quite a different mindset, to the people in multidisciplinary practices where the owner is from a different discipline, plus even within government. So that lawyers are empowered to just say no when it really won't do. And I think that's important. The last point, Alan, is this. We talked quite a lot about the legal landscape and the provision, access to justice. And I have to say, you know, I personally, and this is not, I hope, a party political point, because I put that life behind me, but it is a point which everyone ought to share, that the access to justice in this country now is a national disgrace. And, you know, if it were a health authority or a school, it would be in special measures. And it is not. And somehow regulators are not representative bodies, and it's important that we don't act as spokespeople for the solicitors or the barristers or whatever. But I think it is right that we speak truth to power and we use the information we have to say what is the situation as it is. And here's a suggestion, Alan. We've got a new government sometime this year. Who knows? It might be the same government again, but it might be a new government. Can I suggest that perhaps one of your first tasks is to go and see the new Lord High Chancellor, whoever that is, and perhaps the chair of the Justice Committee, and say, we want to expand what the LSB has already done to provide a sort of state of the legal nation document, which can be laid before Parliament, which can be debated by Parliament each year, to say what is not happening just as much as what is. Suggestion to you.
Thank you, Dave. Let me take that away. I'll take delivery of that, and by all means applaud. It'll give me lots of encouragement. That's great. It's not difficult to remember, and perhaps most of you don't read the Legal Services Act every day the way I do, but right up in front are 8, now 9 regulatory objectives, of which one is access to justice, that regulators have as an objective. Now, we don't have any control over the legal aid budget and all the rest of the whole way the court system is structured, but it's incumbent on us to pursue those objectives in whatever form they take. One of them is rule of law, one of them is about inclusive profession, and so on. So it's all there. These are very highly proactive, positive statements about what regulation should be doing. It's actually, I'm not going to be vainglorious and say unique, but I've never seen it before in regulation in any other sector, where there is something on the face of an act of Parliament saying what regulation is meant to do. So, with all its flaws, the Legal Services Act has got that in it, and we keep those absolutely before us all the time. Everything we do, we try to relate back to one of those objectives. So, interesting suggestion, David. I don't take the word interesting the wrong way. It's simply, it's straight off the top of my head. So I will, but I would like to think about that and how we might explore that sort of idea, whoever is in power later in the year. Thank you very much. I'm going to shut up now and turn to Kathryn.
Thank you. I have to say it gets harder as you get further down the line, because everybody else has said really clever, erudite things, and you've got to think of something that you might want to add. I'm really struck by the fact that we have to remember that people are the centre of what we do. And no one would fail to be moved, shocked, angered by Mr. Castleton's experience. And obviously, as a former victims commissioner, you would expect me to think about people's lived experience of the criminal justice system and of other processes. And it was really good to hear Dana in the last session talk about, let's remember there are humans in this, and how the humans work and react and relate to the excitement that is AI. So people first. And we regulate, of course, we all regulators regulate in the public interest. And that's something that I know is at the forefront of all my colleagues at the BSB's minds. The second point I want to make is about access to justice and trust. Scandals like the post office really do shine a light on the way in which we can have trust and confidence or not in a legal system, in a justice system. I wonder if we should ask ITV to do a documentary about the criminal justice system and the parlous state of it, because it seems the only way that things change in this country at the moment is getting ITV to do a documentary about it. So, maybe we should bring them in and ask them to look at it, because if we can't have trust and confidence following scandals, how can we have trust and confidence in a criminal justice system where there are huge backlogs of cases waiting to go into Crown courts, which are crumbling and the roofs are falling in? I think you're right. I think this is something that we as regulators, as legal advice providers, need to really take strongly as an action to take forward. I would also in addition to that, want to pay tribute to those of you who work in legal advice centres, consumer advice centres. It seems to me that your client group is getting bigger and bigger and bigger, and people's difficulties and challenges are getting more and more complex and more desperate. And I think you are the absolute heroes and foot soldiers of our legal system, our fragmented legal system in this country. And we should all remember and celebrate the work that you do day and daily for people who simply, not only can they not afford legal advice, but they can't afford to put food on the table. And that's something we need to remember.
Thanks. Thank you very much, Kathryn. Some of my colleagues and I visited Nottingham during the last year, where the law school runs a regulated law firm, which is also used as a kind of proving ground for students and so on, and also going on into court with people. And it acts as an advice centre. It only acts on referral from local authorities, but it's a very worthy venture. I think it's great for the students. It gives them exposure to different parts of life, different types of law, and of course there are qualified lawyers on hand to refer to as necessary. I'd love to think that every law school would have something like that in due course. It's not, again, something we can impose, or it's a little bit above the pay grade of the LSB, but we were very impressed by that indeed, because I think it was simply a win-win all round. For clients, for lawyers, for potential law firms in the future, and for the students on their way. So that was great. So we're going to come to Chris Smith. Off you go.
Well, if number 3 was difficult, number 4 is even worse. And I have to say, I love David's idea of the LSB doing a State of the Legal Nation report each year. It has the added advantage that it is something that can be done without demanding huge resources to do it, but it will shine a spotlight on many of the things that actually do need resources to put right. It is in danger of falling into the very brave minister category. But nonetheless, I think it's something that should be picked up and really run with by the LSB, and you would have a lot of us regulators cheering you on in that. The 2 bits of background that we need to be aware of is firstly a developing lack of trust in institutions, authorities, experts amongst ordinary members of the public. And I don't think there's anything we as regulators can do necessarily to put that right. But it is something that we all need to bear in mind when we are making decisions and proposals. The other bit of the background is really what Dana touched on in the previous session, and that is encountering the law is a frightening experience for most ordinary people. And helping to make it unfrightening and bringing clarity to that is something that we as regulators all, I think, have a responsibility to do. At IPReg, we regulate patent and trademark attorneys. There are just over 4,000 of them in the entire country. The big issues for the immediate future for us, you've touched on already in the course of discussion today. They are firstly barriers to entry to the profession, and making sure there are good routes into the profession for those who might not come from a traditional background. Secondly, ensuring that AI can be used for the benefit of the client and the consumer rather than for the disbenefit. And thirdly, making sure that we begin to create a more diverse profession that better reflects society as a whole. Those, I think, are probably common themes across all the bits of the legal landscape. It also occurs to me that we need to be very clear about one thing. The regulator of a legal profession is there primarily to protect the customer. We're there to do three things. One is to enable the profession to feel proud about its expertise and its professionalism. The second is to protect the customer. The third, and this is the bit we constantly have to remind ourselves of, is we are also there to protect the public interest. And a lawyer working in-house for the post office will have been working directly for their client. Will they have been working for the public interest? That's a much more difficult question. And regulators need to bear in mind all the time that the public interest has to be protected.
Thank you very much indeed. So thank you for all those thoughts. There is a machine down there threateningly giving me a countdown on how many seconds. We literally will tell me how many seconds we've got left, which is very exciting, but I don't particularly want that right now. I'm going to invite questions. I will say, because you know, nobody is here to discuss individual cases before we even start on that. So if there's an issue over that, take it up with the authority concerned, but that's not for today. A question, a gentleman in a white shirt, or someone in a white shirt anyway.
Thank you. Good afternoon. It's Jeremy Barton. I made a comment earlier on, but I want to build on it a bit this afternoon. I'm been many years in-house in the accounting profession for large accounting firms. And I'm very used to being regulated in terms of the audit regulation. One of the themes of regulation as being an improvement regulation mindset, I think, is really important in this conversation. And my comment and question is very much focused on the in-house community. It's quite tremendous to have such a range of regulators on the panel, and also to have had, I think we still have among you a representative of the board of the architects registration board, I think, as well. So it's truly multidisciplinary in many ways. Now, in-house teams are very often multidisciplinary. And to the comment made earlier, there will be IP, there will be in-house teams with IP attorneys. There are in-house teams with barristers. There are in-house teams with auditors, all within the legal teams. And it seems to me that the regulatory oversight of the in-house teams and support of in-house teams, we're in catch-up mode at the moment. And I know the SRA next week, we look forward to those discussions. But I wonder also whether the in-house community and the in-house profession at some point warrants its own regulator, in a sense. We have, I think, about 20,000 barristers supported by a regulator. There are many more in-house members of in-house legal teams. And I wonder whether it now warrants a separate regulator. But my question is really focused on the coordination across sectors regulators. That hasn't been discussed yet. But in as much as large organizations may be regulated by other regulators, those regulators very often show an interest in their compliance and legal teams. And so for me, it would be to ask, I'll be interested in the panel's view on the opportunities to coordinate with other regulators outside, if you like, the legal family, I think, of regulators that was mentioned, because there may be an opportunity, and all of that in the interests of public interest and society's trust in the in-house legal teams. Thank you.
Thank you very much for that. I would comment ever so briefly before I invite someone to volunteer to answer that one. One of the regulators that LSB oversees is the ICAEW in respect of its legal work, in the legal work that some of its members are authorised to do. So we draw, very interestingly, you can draw some insight from that as well. That doesn't answer your question. I'm simply saying that the thought of cross-fertilization of that kind is not unconscionable before we even start. David, I saw you nodding a little bit, which suggests you might be winding up for an answer. So
well, I'm not sure about that, because cost lawyers are probably least likely to actually be outside the field of a firm of solicitors, which is quite common, or working individually. So in terms of my regulated community, it probably doesn't apply. But I used to be on the SRA board, so I also have some thoughts about that. And I think what I would say is certainly we need to talk to between regulators in other professions. But what I alluded to earlier was a degree of cross-fertilization, which actually leads to convergence anyway, because I think it's an absolute nonsense for there to be totally different provisions that apply to different professional areas, often working in the same office, with the same basic principles of what is proper behavior in respect of the consumer. So the more we can get convergence, the more we can actually be working from the same basic set of rules, the more sense it makes. And certainly in the sort of cases you mentioned, I mean, when you talk about the money laundering requirements, it would be a nonsense if there were totally different regimes for everybody working in that office. And as you know, there is regulation that covers that. But it does seem to me that's the future. And I am, in my more apocalyptic moments, I think we're coming to the end of the professional era in the sense of separate professions. I think actually we're talking about people who are qualified and are willing to enter into a social contract with the public in terms of their codes of behavior, which will allow them actually to move much more easily between different facets of multidisciplinary teams, because as we heard from the AI discussion earlier, it's all going to become pretty academic. What you started off at is what you end up as.
Yeah, good. Very, very good point. I think it's probably fair to say, I certainly would assert that codes of ethics across the different legal sectors, in different parts of the legal sector, are not greatly different. Yeah. And even if you go outside to healthcare and other areas, codes of ethics still contain much the same kind of provisions. It would be quite easy to construct unified ones. I'm not saying anyone should. I'm simply saying, underlying David's point, that we are working to common principles. I'm going to move straight to a question online now. So we've included them. And Gabby.
Hi, Alan. So there's been a bit of commentary around the points that were made by Chris and Jeremy around how does the regulatory community ensure consistent approach across the professions, particularly for the in-house lawyers who might have competing loyalties or obligations. And there's also a question around relating, embedding professional ethics into everyday practice rather than an add-on that we've been talking about throughout today. And how do we empower all lawyers to question or call out bad practice? What can be driven by regulation and what needs to be driven by culture change in the practice environments?
Okay, thanks very much. I don't think regulation and culture change are incompatible. I mean, they go together, and a lot of these things must lock together. I'm going to invite members of the panel to comment on that one, because this is a theme that's run through the day. But certainly, it's my view that ethics isn't a kind of component over there any more than, say, communications is a component over here. It belongs everywhere and runs right through, and should not be compartmentalized like that. Well, Kathryn first, and Chris.
I'm happy to pick up the point about ethics. I guess with my background, my most recent background, you'd expect me to be quite interested in ethics and standards. And the conversation that we were having this morning over our breakfast was about integrity. And barristers are required to act with integrity, ethically, and with honesty. And if anyone is aware of any barrister breaching those professional obligations, that's what the Bar Standards Board is there for. For me, integrity is how you behave when no one's watching. And, you know, there are many, many examples of people who do not live up to that expectation that we all have of our lawyers, of our members of parliament, of our doctors, of our nurses, of our midwives. And the kind of core principles, the Nolan principles, and I know that David and Chris will be very well versed in these, of accountability, leadership, integrity, honesty, selflessness, and objectivity are as important when we're talking about the law and how the law and legal services apply to people as they are for civil servants, members of parliament, and others. So integrity is not a bolt-on. Integrity is how you behave when no one's watching. We have our training providers set exams in ethics, and we should all be holding each other to account to practice and behave ethically and with integrity.
Thank you, Kathryn. Chris?
I have to confess for my sins. For a couple of years, I was a member of the Committee on Standards in Public Life, responsible for the implementation of the Nolan principles. And I'm very glad you gave the 7 principles, because I would have struggled. It's a really interesting question, because regulation and culture change are part and parcel of exactly the same thing. And in IPReg a couple of years ago, we did a complete review and rewriting of our regulations, our guidelines, our procedures. And Alan will be very familiar with this because he was our board member at the time, who led the oversight of that process. And one of the things we did in that was to put the principles of ethical behavior and integrity right up front in the new set of regulations which we put in place. This has to be completely part of exactly the same process of doing the detailed bits of regulatory action and oversight.
Thank you very much. I'm going to take one more question from in the room. Yes, at the back with a white top.
I spoke earlier, so I'm the accountant but with the consumer panel. So I'm actually ex-internal audit myself. And I think one of the questions I have is about investigations. Now, we saw in the post office scandal, it came about because MPs, you know, the media and everyone started working together. And it's like, if there is no access to getting the facts, because as an internal auditor, we would look at the facts and then try and see what the process is, how it's worked and where it's failing. I guess, how could we upskill investigations, particularly amongst lawyers? Because that's where I think there has been some failings.
Thank you very much. Going to invite Anna, do you want to, can I drop that one on you?
Yeah, you can, but I'm not quite sure. Can I just clarify the question? Are you asking how those who are investigating solicitors and other legal practitioners can be upskilled, or are you?
I mean, it's a bit of both. So in-house first, and also potentially regulators, because like you said, I think some of the legal regulators are actually getting burdened because other regulators are doing badly. And I think, you know, then you're always relying on legal ethics where it should be elsewhere. But I think one of the big fundamental flaws amongst all regulators and has been investigations, and coming from an internal audit background, you know, it's like, what are the facts? What are the processes? That's what I come back to. And that's where I think it's being done poorly. So how could you upskill people to do that better?
Okay, so I think I mean there's a number of bits to that question. Perhaps I'll start with the internal dynamic. I think so SRA at the SRA we've had an objective this year, and it will flow still through into next year to improve our the timeliness and particularly the timeliness of our investigations, and that, to be fair, has meant that we are having to think about how to really re-engineer those processes quite dramatically. So this is not a kind of easy fix. This is quite a significant change. It's actually a cultural change in terms of the way that people inside the organisation. We have quite a few people inside the organisation dealing with these sorts of things, but it's also a re-engineering, and it is an upskilling. So I think your point is well made in terms of regulators, and it's no small feat, but you know, it is for us already getting significantly better, and we have every hope that it will get to an even better place in quite short order, because I think we're at the sort of, you know, the point at which we'll see the fruits of a lot of work. I mean, in terms of upskilling in investigations in-house, I mean, I think that's probably a conversation to have in the context of, for us at least, in the context of our proposals around in-house lawyers, and what guidance we can offer them about what they should be doing, and whether there also needs to be guidance from others. But I would, so perhaps I won't comment on that so much, but I would say, in relation to drawing that together with something someone else said earlier on about working with other regulators. I mean, what has become increasingly important for us as a regulator, for sure, is that we are working with other regulators. So we work very closely with the FCA in relation to AML. We work very closely with the Information Commissioner on a variety of things. We work with, of course, the other legal regulators, with the FRC. And we're part of a network of regulators where we exchange thoughts. But we actually work. That's a kind of more thinking piece as opposed to a doing piece. We work in tandem with regulators on a range of specific issues, which I think you probably wouldn't have seen 10 or 15 years ago, but you definitely see as a key part of what we do now. Can I have one comment on ethics?
Quick one, please.
Quick one.
I'm getting threatening messages.
Oh no! All right. Well, I was just going to say on ethics. So there's something about getting it right in the first place, and I won't comment on that in terms of the training and support for people as they enter the profession. But I think the thing which people have talked about a lot today is about the importance of not just changing cultures, but changing behaviours, and doing that through the life of lawyers, sort of as part of what would be continuing competence. And I'm hoping that that's something that we will reflect on when we complete the work that we've been doing on a thematic on continuing competence, because I think there's an opportunity to reinforce some of those messages about the importance of ethics in that framework. So maybe watch this space.
Thank you very much indeed, and I'm sure we'll certainly be watching that. I'm going to draw it to a close now, so I want you to, first of all, to thank the panelists for me. Thank you. I will repeat the request I made right at the beginning, not to regard this as a talking shop, but as a starting point for discussion further, to see how you can collaborate with others, how your organizations can work within and around the regulatory world, and by all means get in touch with us at LSB if we can help. I want to conclude by thanking all our speakers and panelists. There's too many of them to list now, because I believe if I take much longer, there's a trap door here and I'll probably disappear, which you know, might make you very happy. So thank you very much to contributors from a very wide range of fields. As has been said, we all learn from that. Thank you. I'm not sure whether anyone's in here from the exhibitors, but those of you who are, thank you very much for helping to broaden our perspective by being here today. Thank you also. You'll pass on, I'm sure, thanks to the venue team for providing a great space for a conference, and light and area with some fantastic food, at least I thought it was. Thank you to Elizabeth Davis. Elizabeth, stand up and take a bow. For so graciously getting us through and keeping us to time. And also thank you to our fantastic team here at LSB for coordinating the whole event, putting it all together, and generally trying to keep us in order. Thank you very much indeed.